Good morning, everyone. My name is Carlos Portillo. I'll be discussing professional conduct in the age of automation. In this presentation, we'll be diving into the ethical considerations of using generative AI in the legal practice. Keep in mind, this is only a 15-minute presentation, so this is by no means an exhaustive list that will be diving into the minutia. But in my opinion, there are two types of lawyers. There's successful lawyers and not so successful lawyers. One can extrapolate on incomplete data, and if you enjoyed that joke, I came up with it. And if you did not enjoy that joke, Professor Feuderand came up with it. As AI technology rapidly advances, its application in the legal fields are becoming increasingly prevalent. While AI offers a number of benefits, it also raises significant ethical concerns. This presentation is based on the guidelines from the State Bar of California and insights from the MIT Computational Law Report. These resources provide a framework for understanding the ethical use of AI law. And here I have hyperlinked my sources. I don't know if this presentation will be available to everyone, but
it will be circulated to the attendees.
Yes, so you can just click on there and you can see my sources.
Like VLEX, except by people.
Here on this slide, you can see the duties and obligations outlined in both our references. Though both references share commonality, there are some duties that are unique to each, but in the interest of time, I have taken the liberty of combining some duties and omitting others from my presentation. So let's take a moment to familiarize ourselves with some of the duties before diving in. As you see here, the duty of confidentiality is number one in both California and MIT. Another thing you can see is the duty of competence and diligence. Though the wording is a little bit different, you can kind of see it here in MIT as the duty of fiduciary care. For our eagle-eyed viewers, you might be seeing point number 2 and point number 5. They look very similar, the fiduciary care versus fiduciary loyalty. So I just wanted to highlight the differences between these before moving on. Fiduciary care just basically means we do our due diligence in seeing that the AI output is correct. So what is the AI giving me? Is this actually a legal case? And if yes, you can move on to number 5. Does this case actually benefit the client? It doesn't really matter if the case is real, if it hurts our case. So number 2, make sure that the information is correct. Number 5, make sure that the information is correct and it's helping our clients. Okay. Though there is a lot of ground to cover, I'd like to focus on 5 key considerations. The duty of competence, the duty of confidentiality, the prohibition of discrimination, harassment, and retaliation, communications regarding generative AI use, and charging for work produced by generative AI and the cost of generative AI. Let's start with our first key consideration, the duty of competence and diligence. The applicable authorities here are rules 1.1 and 1.3. Lawyers have the duty to use technology competently and diligently. This means not only understanding the law, but also being proficient in the technologies used. Generative AI presents new challenges and opportunities, requiring us to be diligent in our analysis and review of AI-generated output. Lawyers must not become over-reliant on AI and have an understanding of AI's limitation. AI should be used to enhance, not replace your professional judgment, because it is possible for AI to output information that is false, inaccurate, or biased. And if you don't believe me, just ask Stephen Schwartz, who submitted a legal brief that included 6 fictitious citations in the Mata versus Avianca case, as stated before. Lawyers should always critically analyze the output and check for accuracy. By staying informed and continuously improving our skills, we uphold the duty to provide competent representation to our clients. AI can significantly enhance legal competence by streamlining research, managing large volumes of data, and aiding in document review. However, lawyers must skillfully integrate AI by carefully composing prompts and ensure all outputs are accurate and reliable. Moving on to our next consideration, the duty of confidentiality. Applicable laws here are Rules 1.6, 1.8.2, and the Business and Professional Conduct Code Section 6068, subsection E. As legal professionals, we are bound by strict rules regarding client confidentiality. This duty extends to the use of generative AI, where the security and protection of our client information are paramount. Generative AI can use input information for training and share it with third parties. That's an open source AI. Most law firms would not be using open source. They'll be using closed source. But even if the AI doesn't use or share inputted data, there could still be a security issue. It's crucial to ensure that it's crucial to make sure the information you are providing to the AI is anonymized, meaning there's no confidential information being put into the AI. We must ensure that any AI application that is used maintains the high standard of data security and confidentiality by consulting with our IT or security experts to ensure the systems are secure and that the client information is anonymized to prevent unauthorized access. By maintaining the confidentiality of our client's information, we uphold the trust and integrity of the legal process. Now let's discuss the prohibition of discrimination, harassment, and retaliation. The applicable authorities here are Rule 8.4.1. Incorporating generative AI into our practice requires us to be vigilant against biases that may be inherent in the technology. We must take proactive measures to prevent discrimination and ensure that the use of AI promotes equality, inclusivity. Firms should implement continuous learning and policy mechanisms to identify, report, and address AI biases. Managerial and supervisor lawyers should establish clear policies for the permissible use of generative AI and ensure that the firm adopts measures to ensure compliance with professional obligations. Subordinate lawyers must not use generative AI in a way that violates their professional responsibilities, even if directed by supervisor lawyers. I will say that again because that's very important. Subordinate lawyers should not use AI in a way that would violate their professional responsibilities, even if directed by supervisors. The defense that I was just following orders will not protect their license and could open you up to sanctions. Awareness and productive steps are critical to uphold ethical standards and promote fairness in legal practice. By establishing policies and mechanisms to address potential biases, we create a more equitable and just legal system for all. Right. Communication is key when it comes to the use of generative AI. The applicable authorities here are Rule 1.2 and 1.4, 3.1, and 3.3. We must be transparent with our clients about the use of AI technology in their representation, including its benefits and its risks. By engaging in open and honest communication, we empower our clients to make informed decisions about their legal matters. There are some clients that may be a little apprehensive about using AI and they would wish for a human to be doing all the research, while other clients may encourage the use of AI as a cost-saving measure. So just remember to be open about your use of AI and make sure the client knows exactly how you're going to use it so that they can be informed and give the informed consent. Additionally, we must review any applicable client instructions or guidelines that may restrict or limit the use of generative AI, ensuring that we adhere to our ethical obligations. Moving away from our clients, honesty and accuracy are essential when presenting AI-generated outputs to the tribunal. We have the duty to review and validate AI-generated content for accuracy before submission to the tribunal. By doing so, we maintain the integrity of the legal process and advocate effectively on behalf of our clients. Lastly, let's talk about charging for work product generated by AI. The applicable authority here is Rule 1.5, and the Business and Professional Code section 6,147 through 6,148. While generative AI can enhance efficiency, we must ensure that our fee arrangements are fair and transparent. We should charge for actual time spent on task rather than the time saved by using AI, and clarify fees associated with the use of generative AI in our fee agreements. By aligning our billing practices with ethical standards, we demonstrate our commitment to integrity and professionalism in the legal profession. Fee arrangements should detail the basis for all fees and costs, including those associated with AI use. Clear communication about these practices ensure clients understand and consent to the billing methods. Transparency in billing practices foster trust and aligns with our ethical standards. In conclusion, the ethical use of generative AI in the legal practice requires a careful balance of technology proficiency and adherence to professional responsibilities. By following these guidelines discussed today, we can harness the benefits of generative AI while maintaining the high standards of professionalism and ethical conduct. Thank you for your time and attention, and let's continue to navigate the intersection of technology and law with integrity and responsibility.
So